Good morning and welcome to today's webcast, the Corporate Transparency Act, Maintain Filing Compliance. Before we begin, I'm going to play a brief housekeeping video.
Welcome, and thank you for viewing our webcast series. Before we begin, please keep the following in mind. You can customize how you view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can adjust window size and placement or enter full screen mode using the controls at the top right of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons that relate to a different aspect of our session. You can download a PDF of today's slides from the Slide Deck and Handouts widget. You can ask questions by typing in the Q&A window and clicking Submit. We'll do our best to answer all questions or follow up via email. If you experience technical difficulty, refresh your browser by hitting the F5 key. This presentation is not legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
I'm pleased to introduce today's presenters, Moss Adams partner, Andy Mattson, and Elizabeth McMorrow, partner at Elizabeth A. McMorrow Law. With that, I will turn it over to Andy to get us started. Andy?
Thanks everyone for joining. What we're talking about today is the beneficial ownership information filing obligations that over 33 million companies and entities in the U.S. are going to have as a result of the Corporate Transparency Act. These filings are, the Corporate Transparency Act was a part of the Defense Department Authorization Act at the very beginning of 2021, and it has nothing to do with the U.S. tax law. It is a filing that's required under Title 31 of the Federal Code as opposed to Title 26 of the code, which covers, Title 26 covers the Internal Revenue Code and tax filings. So we got an initial question, this, hey, why does anybody have to worry about this? Shouldn't the IRS already have this information that, say, LLCs have filed? The answer is these filings are not made with the IRS. They're made with a government law enforcement agency known as FinCEN. And so essentially, they don't talk. The purpose of the Corporate Transparency Act, again, which affects, expected to affect 33 million entities in the U.S. this year, is to essentially expose the beneficial owners of entities. As of right now, unless such a filing is made, nobody knows in many states who owns LLCs, C Corps, that kind of things. So it's just, again, it's a law enforcement thing. It's not a tax thing. And the audience today is primarily investment funds, venture capital funds, PE funds, although I see we do have some investment advisors and family offices on. But essentially, the Corporate Transparency Act has some potentially unique implications for funds and their general partners. But essentially, what we want to cover today is the types of entities that funds such as you are going to have to worry about. B, the nuances for some of our general partners and who sit on boards of companies and how this may affect them. And then C, I think it's going to be important once you see this to kind of push the message out to your portfolio companies. Hey guys, you got to comply with this, because if you don't, it's a criminal penalty and it could certainly screw up a portfolio company on a subsequent round of financing. Because this is not a tax filing, most U.S. accounting firms have made the decision that they're not able to do these filings, to prepare these, because it could be treated as unauthorized practice of law. My firm, Moss Adams, is in that boat. So we have partnered with Elizabeth, who is a specialist in this area. And I've worked with Elizabeth for 5 or 6 years in the area of FATCA, and FATCA is very close to this. So that's why she is on, and she is going to be able to take care of any filings that you may have if you don't want to do them yourself. With that, I'm going to shut up and shift it over to Elizabeth, who is our specialist.
Hi, everybody. Thanks for joining us. We really appreciate you making time. I'm just going to click ahead here on the slides. And we've got a deck here that we're going to speak to, as Andy said, some of you are funds, family offices, investment managers. So we'll speak to some of that. And then you can also follow up afterwards. So we just have in here for the many clients of Moss Adams who have set up, what they colloquially known as the Cayman sandwich. And so for those of you who might have this structure or who have invested in, companies that have set up this overall structure, please make sure that once you become knowledgeable, hopefully through today's program, that you are encouraging them to follow through. We do have a lot of clients, myself and Andy, that we share who are very bright young entrepreneurs setting up companies outside of the US, and they might push this off as not being as important as building the business. But we do want to make sure they hit the deadlines on this. So if this structure is relevant to you or any of your investments, please make them aware and get them moving on it. Now, just in general, as Andy said, why do we have it? There is an organization called FATF, F-A-T-F, and that is a global organization, sort of like the OECD, for those of you who aren't familiar with FATF. And they do not have any power of enforcement or legislation, but it's governments coming together to set standards. And so FATF has been pressuring countries around the world to be more transparent. And the United States participates in FATF. And so while the US has potentially bullied other countries into creating this kind of system, for example, the Caribbean islands, nations, or territories, the US is now playing catch up to say, oh yes, we are also participating in this type of reporting regime. And so what they're trying to do is get behind who is the beneficial owner. Now, for those of you who are completely transparent through your IRS filings, yes, you're correct. All of this comes through. For example, as simple as, when you're having what we call a W-8 IMY, if you have a partnership, and as part of that W-8 IMY, you have to attach the W-8s or W-9s of the people behind your organization, you're being complete transparent with the IRS. But there are many companies who are not transparent. And I guess the United States is hoping that through this effort, they will be transparent. And so as a result, instead of narrowly focusing on industries that are at higher risk of money laundering, because at heart, that's what this is about, is anti-money laundering. So instead of focusing on the sort of narrow segments of the overall US economy, they are targeting 32 million companies, everything from my small law firm to small grocery stores and things that never imagined that they would be subject to an agency that ordinarily regulates financial institutions. And there are penalties involved. So it is important to become compliant with this by submitting the reports on time and updates on time. And when we say domestic and foreign entities are impacted, I will discuss as we go through the slides. But when we say foreign, it doesn't mean your Cayman entity or your Luxembourg entity. It means a foreign entity that has set up something here in the US leveraging the foreign entity. So in other words, if you are in, say, manufacturing, you don't want to create a tax presence in the United States. So maybe you only set up a sales office. You register that sales office and you are not creating a new company in the US. And you are just really doing it for marketing purposes and not executing any sales agreements. That's what we mean by for an entity. And I'll get into it again in the presentation, but that has been a frequent concern by clients contacting me, where they think all of their entities in sort of a FATCA or common reporting standard type way are subject to this, but that's not the case, and we'll get into more detail. Okay, so moving along here. So what the goal is, again, it's an anti-money laundering regime. So what they want to know is, who are the people behind the entity? Is it just Elizabeth McMorrow, who is behind Elizabeth A. McMorrow Law, LLC? Or are there others? Similarly, here in the United States, even though I mock the fact that some small grocery stores would be subject to this, it actually is an issue here in the US, where some small grocery stores are really being used for drug cartels to wire money back to the country where the cartel is located. And so the small grocery store might have set up a Western Union outlet in their little store, and there's a lot of money coming through that. And so those are the types of high-risk targets, but everybody has been pulled into this. And for those of you who are in family offices where trusts are involved, it gets even more complex as far as the number of people who would have to be reported. So when we're looking at who a beneficial owner is, we are talking about control and ownership. So right now we have sort of leapt into assuming that you have a reporting company. And to step back, because some of you have investment funds and other types of arrangements, and you might have complex portfolio of how you're investing or how you're advising your clients. So with the Corporate Transparency Act, you should assume if you have a US entity, it is subject to this. And then you back out. You say, there are 23 exemptions, and do I fit into any of those 23 exemptions as an entity? And for those of you who have funds, it is possible, because what CTA is doing, the Corporate Transparency Act, is trying to target that part of the United States which is not subject to regulation already. And so if you have a fund structure that is subject to one of the regulatory regimes here in the United States, then it is likely that that particular pieces of the overall structure are going to be exempt from reporting. Now, if you believe that and for some of this, I'll give you, my website you'll have at the end of this, and I also provide you, the agency is called FinCEN. It is part of the U.S. Department of Treasury. I provide you the website in these slides, so you can also look at the materials they provide if you prefer. However, if you conclude that you are not subject to CTA, any one of your entities, you need to write that up and have that in your compliance. Because if there were any questions by the US government, you don't want to have said, oh yeah, we somehow came up with that, we weren't subject to it. You want to have something in writing. It can be by your in-house counsel, your outside counsel, somebody who is just doing a memo to the file indicating which specific exemption it is that applies to you, okay? So now we're going to assume that your whichever company is subject to this. And we're going to say what needs to be done. Well, what needs to be done is the company has to submit a report to FinCEN. For any company, and we'll go over the deadlines, that was created before January 1, 2024, you have till the end of the year. but you want to do it sooner because I anticipate the system will crash in December for sure. Sorry if I'm a pessimist on that. As part of that report, you're providing some basic info about the company. You're also providing information about individuals. So who are the individuals? Who are these beneficial owners? So it's a very broad scope of determining who the beneficial owner is. They're looking, they meaning the US government, are looking at control and ownership. So with control, we're saying direct or indirect. So there could be somebody in the shadows who is exercising authority over things, and that person would have to be included in the report. So if somebody is exercising any kind of substantial influence over important decisions, if an individual has authority to remove senior officers or a majority of the board. And then what we frequently say in the US, we call the C-suite, and that means the senior officers of the company. And so I am looking as C-suite at president or CEO, the CFO, chief financial officer, the COO, the chief operating officer, the GC, meaning general counsel or the top legal officer. And it could be that somebody exercises these types of roles, but you have given them a different title. They would still be reported. It's not about the title, it is about the power and the control that the person exercises over the company. There has been a large number of what we call FAQs, frequently asked questions, of this agency, FinCEN, and they have been providing a lot of updates to their FAQs, which is helpful. And so we do not have to go further than the titles or the whatever title it is, the functional area that I've listed here. Treasurers do not have to be included in this type of reporting. And other people who would be below these categories do not have to be. I know a lot of you have companies or invested in companies that are technology, and we know that the chief technology officer is incredibly important to the success of that company. However, the CTO or CIO, those types of functions do not have to be reported for purposes of this. So you could end up with quite a long list of people. And I have spoken with my contacts at FinCEN and pointed out just how large of a list they could end up with, and isn't that counterproductive to understanding who the true power or ownership is behind the company. And unfortunately, the response was the more information, the better, which to me, as someone who's concerned about privacy, I see that as very disturbing, because this is going to be a very large, what we say, honeypot of information that the government has, but we have no choice but to submit this information. Now, on the ownership level, we're looking at a 25% benchmark of ownership. However, when we're thinking about ownership, it is more than just, say, common stock ownership. The FinCEN is looking across all forms of ownership and expecting the company to do a calculation. So even if there is a type of ownership that has been set up with a future powers, then that could still be pulled in. And so this chart here I have taken directly from FinCEN's materials, because you can, and it's kind of small, the writing on the slide, but you will have these slides, and so hopefully you can take a look at this. But you can see that even if you have a creative investment structure that might be useful for other purposes, other business purposes or tax purposes. For purposes of the CTA, it could be that you are pulled into being a current owner and hitting the 25% benchmark. And for many of you, even if you have structured the ownership interest such that you have less than 25%, you could still be pulled in because it is possible that you are a member of the board of the company. And so when we are talking about control, we are talking about C-suite, we are talking about board members. And so it could be, oh, I only have 17% interest in the company, but I'm protecting that interest by sitting on the board. So now, yes, you are a beneficial owner. Because when we are doing this reporting, we are not indicating that Andy is on the board, but not an owner. We don't indicate that anything about Andy other than Andy Mattson, beneficial owner, Elizabeth McMorrow, beneficial owner. And it could be that we're not an owner at all, that we are just executives, but it's still the same term. You are either a BO or you are not. And there is not a breakdown within the report to designate why you are a BO. So now we've determined that you are a BO, that you must be included in the company report. So what is the data that is required? So first of all, the data that is applicable to the company is very basic. So it's the name, the address, and when we say the date of formation, really what we want to know is, was it before or after January 1, 2024? So when you are pulling together your documentation to prepare the report, whether you are doing it yourself or having an outside provider help you, you do not have to worry about the specific date of formation if it was before January 1, 2024. If it was after January 1, on January 1 or after January 1, 2024, then the specific date is relevant because it is a different deadline. So pre-2024, your deadline, this first report, is December 31, 2024. If you created a company this year that is subject to CTA, then you have a much shorter time to get this done. You just have the 90 days. Then next year, it's shorter. So now, foreign reporting company. Again, as I said, it's not, oh, well, we have a Cayman entity in our Cayman sandwich structure. No, that Cayman entity is not subject to it. What is subject to it is if you set up some kind of office here in the United States, you had to register the office, but you did not form a U.S. entity. You did not form an LLC or a C Corp. You just registered, for example, a marketing office. That's what we mean by foreign reporting company. And then, of course, the tax ID. If it is a U.S. entity, that would be your U.S. tax ID. And if you only formed, for example, a marketing office here in the U.S., then that would be your foreign tax ID. So now you yourself are a BO. What is the government collecting on you as an individual? I personally think it's a little invasive. It is your name, it is your date of birth, and it is a photo ID. And with the photo ID, if you have a U.S. driver's license or a U.S. passport, you would submit one of those two things. If you did not have one of those, you could submit some type of other U.S. ID. For example, in the United States, for people who don't drive a car, we have an ID that looks like a driver's license. If you don't have a U.S. ID, then you would submit your foreign passport. So being ethnocentric, we call it foreign. So it's your non-US passport. Now, if you are able to provide a US ID, I personally am recommending to people that you provide your passport rather than your driver's license. Your driver's license has more personal information about you on that ID, whereas the US passport has limited information. And also from a update standpoint, your US passport is 10 years, and generally our driver's licenses are about 5 years. And when your photo ID expires, you are required to submit an update in this new system of CTA. And so the passport should give you a longer time before you would have to update that document. And, again, you want to be protecting your data. We can't control how the US government is protecting our data, but we can protect how we are doing it in the preparation and reporting process. And so I will talk to you a tip on how to do that. And that is called a FinCEN identifier. So if you are only having to report your personal information for one company, then the FinCEN identifier might not be a useful idea for you. If you are required to report yourself as a beneficial owner across more than one company, then the FinCEN identifier is useful. That is because the reporting company is responsible for doing the report. If, for example, you are a VC and you have invested in 5 different companies, 5 different startups, they're in various jurisdictions, and the person from that company who's responsible says, hey, Andy, I've got to file this report. Please send me this personal information about yourself and a copy of your passport. Well, you don't want to send that out 5 times. From an administrative standpoint, it's annoying, but from a privacy standpoint, you've now got your personal information sitting inside 5 different companies who may or may not have good processes for privacy. The alternative for you is to go into the portal and create an identification, an identifier, they call it, that only is for this purpose. It is not something you would use as a tax ID or any other way with the United States. It would only be for purposes of CTA reporting. You would provide the same information I outlined on the previous slide. You would immediately be given a number. And when each of the companies you have invested in or on whose board you sit ask for your personal information, the only thing you would give to them is this identifier. This also benefits the reporting company because now they are no longer responsible for updating your information. For example, you have to update your information if you move, if your residential address changes. So now that burden is no longer on the company, it is on you. You now have a direct relationship with FinCEN, and it would be one-stop shopping. You would only have to make any update to your expired passport or to your residential address, one place in there, and you wouldn't even have to tell the companies that you have updated that. And so that would be your personal business about your information and when you update it. It would also make it better for your investment companies because while you might be a responsible person, perhaps your fellow board members or fellow investors are not. And it would then be on the reporting company that they could be fined or be found to be out of compliance because the other board members or investors did not update their information with the company. So I recommend that companies require the board members and VCs to provide identifiers these are small companies that a lot of you invest in, and it's better to just let them focus on growing the business. Okay, now company applicants are relevant to any company that was created after January 1, 2024 or later in all future years. If all of your companies were created prior to January 1 of this year, this does not apply for you right now, but hopefully you're expanding your investments, and so this might apply to you in the future. So the company applicant is included on the company report. And so these are outsiders who helped you as a company register your company, for example, in Delaware. So it could be that you have a service provider who is an accounting firm or a law firm, or just a company that specifically deals in registering companies as their service. And they are the ones who actually go either with paper documents to register your company or do it online and type in the information. So in the context of a law firm helping you, it could be the partner that you deal with and maybe the paralegal or some type of assistant. You would have to have the information from both of those people to include in the company report. And so you can see how that is kind of burdensome, because you have all sorts of deadlines going on when you're creating this new company. It could be you're doing a merger or an acquisition or founding a new company. You must make sure that you're obtaining this information. It could be somebody you're dealing with on a regular basis, so you do have the information. The people who do this as a regular service most definitely are going to have obtained FinCEN identifiers. And so they will just be providing you that number, which will go into your report, and then you do not have to worry about anything else about them. You don't even have to know their name, because it is only the identifier that goes into the report, and then FinCEN is able to link that together. So these are examples of who might end up being a company applicant. And again, back to what I told you, I spoke to FinCEN and said, why do you want a clerk who is just entering data into the system? And the FinCEN employee said to me, he doesn't see what the big deal is. He has to give his information to the federal government because he's a federal employee. Not a good answer from my perspective. But it is a maximum of 2. Even if there was a team supporting you, it'll just be at most 2, hopefully, identifiers that you obtain. And again, this is the cutoff. Originally, FinCEN said they wanted company applicants from everyone. And if you have a company 100 years old, good luck finding out who that was. Finally, after many complaints in the rulemaking process, they acquiesced, and it's a start date of January 1, 2024. The company applicant reportable data is the same as the BO. However, the company applicant data does not have to be updated. So even if a company applicant registers your company in Delaware and gives you their personal info, they do not give you an identifier, it does not matter. This does not have to be updated in the future. So that is one less concern for the company. Now, deadlines and reporting options. So the reporting options. So as Andy said, because this is through FinCEN and not through the IRS, both of them are within the U.S. Department of Treasury. There has been problems within the U.S. where accounting companies are not able, for a variety of reasons, to offer these services. You will see some very small accounting firms that are, say, 1 or 2 man shops who might then set up a separate company to do this. However, it's, for people like Boss Adams and others, it's very important that they need to make sure that they are not crossing any lines. And so there are service companies that you can turn to, and I'll give you a couple of examples. You can turn to law firms. It does not have to be a lawyer. So, and it can be done internally. So while I'm happy to help you, the biggest goal of our presentation today is to make sure that you're aware of the requirements and that everybody hits the deadlines. Obviously we all want to make money. We're all capitalists here, but that is the number one thing. And that is why I'm also giving you information on the next slide of other services you can use. So if you choose to use me, I'm located outside of Boston, which is northeast of New York City. And the types of services I provide, you can go to my website and you can see the variety of legal services I provide. And then this is some of the in CTA specific things. Now, other reporting options, because we just want you to do it, whether it's through me or otherwise. So other reporting options. So on a sliding scale where I'm viewed as sort of the more full service option, the next option would be with this company, Parasec, and the 2 companies I'm recommending here. There are other companies who are like them. I just happen to know Ian and have known him for several years. And then Stacy is the marketing person, but I know the owner of this small company. And so I know that these people will be honest and do things correctly. But there are plenty of others as well. So with Parasec, this business model is, this company is the type of company that you turn to get your company registered, or if you have to get some kind of apostille or legalization of a document, they provide those type of services. In addition, they have set up part of their company to deal with CTA. So the people are more clerical type people. They will provide some assistance in helping you complete the preparation, and then they will do the actual filing in the FinCEN portal. So that's one type of service provider. Another type of service provider is secure compliance. So they have created software. So that would be a subscription basis, and that would be that you are doing it in-house. And so you are maintaining a dashboard in-house. This could be if you have a wide variety of investments, if you have a large fund structure where some of the funds or other entities within the overall structure are subject to CTA, then that type of solution might be useful to you. Then if you need, going down the sliding scale of self-help, if you want to do everything yourself, then you would go into the FinCEN portal. I have the addresses there. And within the FinCEN portal, they have created a large number of self-help materials. And for those of you where English is not a first language, or if your staff might not have English as a first language, there are materials in other languages. And even the materials that are in English, they are not written to a lawyer level. The materials are written for a small US business owner who doesn't have a legal background to understand. And so those are types of options that you can use to make sure that you're compliant. Now, the deadlines. This is a chart that you should definitely keep handy if you've got multiple reporting deadlines. So we have their January 1, 2025, but in the United States, January 1 is a holiday, so you got to hit the December 31 to make sure everything goes to plan. And as I said, there's 32 million companies subject to this. And the rate of registration, or reporting, I should say, has been very slow. And so there is going to be a big push in December by people trying to hit the deadline. And so I would recommend that even if you do not do this in, what are we? We're in June. So even if you don't do this in Q2, get it done in Q3 by, say, end of September, October latest. Just get it out of the way, because that portal is not going to handle the crush. And then, of course, if you have created an entity during this year, it is very important to hit the 90-day deadline. And you most definitely should be updating your deal lists as far as the tasks associated with any of your investments, mergers, acquisitions. You want to make sure that this task is added to the list. And you will see that for next year, let's see, updated, correct, registered, let's see, 30 days. Oh, I don't have it. So next year, it goes to 30 days. So I haven't made that explicit here, but you can see created January 1, 2024 to December 31, 24, you have 90 days. Oh, I'm sorry, there it is on my list. Created after December 31, 2024, only 30 days. And 30 days can go very quickly, especially if there's some type of holiday in between there. Updated reports, that is another thing that can catch you out. And so it's important to have identifiers for the investors and the board, because then that penalty is not on the company. That penalty is on the individual. Because if it's just a change of address or updating a new photo ID. Now, corrected reports, that has to happen 30 days after you become aware. And so again, you don't want to say, oh, well, how will they know that we became aware? Well, if you're subject to some kind of examination for, I don't know, say taxes, it could be the government agent who is reviewing things sees emails, or SEC audit, anything that you're subject to an audit, they're spotting emails. So you never want to hide things. You just want to be compliant. Now, if you are falling into one of the 23 exemptions, and then you're no longer exempt, then you have to submit a report. So an example of that is one of the exemptions is large operating company. A large operating company means that you have 20 full-time employees, not full-time equivalents, but 20 actual individuals, and your annual revenue is 5 million or more, then you could fall under the large operating company exemption. You have a bad year and your revenues fall below that, or you automate and you do a layoff. You're now no longer exempt. You have to make sure you submit your report within 30 days of no longer being exempt. So those are the deadlines to keep in mind. Now, one thing that we didn't discuss here with this slide are the 23 exemptions. And so what I'm gonna do, oops, go back here. You won't be able to see my slide, but I'm just gonna pull up and read off to you, because Andy was able to see as you were signing on that we have a more diverse audience today than we anticipated, which is terrific. And so I'm pulling up my exempt entities list. And what I'm going to do is I'm just going to read them off. You can't see them. It's not in one of our slides. So these are my short list. For any one of these categories, there's very specific details. So I'm just going to read the titles. Securities reporting issuers, domestic governmental authorities, banks, credit unions, depository institution holding companies, registered money service businesses, brokers or dealers in securities, securities exchanges or clearing agencies, other Securities Exchange Act of 1934 entities, registered investment companies and advisors, venture capital fund advisors, insurance companies, state licensed insurance producers, Commodity Exchange Act registered entities, accounting firms, but not law firms, public utilities, financial market utilities, pooled investment vehicles, tax-exempt entities, entities assisting tax-exempt entities, an inactive entity. However, there are specific parameters there, and it's a very low threshold of $1,000 that's still in, say, the fund. Large operating companies, which I mentioned. And then there is a subsidiary of exempt company exemption. However, it does not apply to every one of what I just read to you. So I didn't read it because I expected you to write that all down. I read it so you would get an idea of the types of exemptions that are involved. And so with the categories that I just read to you, while you might say, oh yes, I am that, it's not just that you call yourself that type of advisor. It would be that you are actually registered with the appropriate authority that is listed in the details of that category. So I read that to you because it could be that you say to yourself, no, nothing I'm dealing with has anything to do with those types of categories. Or you say to yourself, some of mine might fit into those categories, in which case it would be useful for you to either seek legal advice to get a classification of your entities, or on the self-help front to reduce costs. If you go to my website, I have blog posts. I have a blog, and I try to put out basic information. The last 2 months I've been terrible, but before that, I have some things out there, including a couple of posts about the exemptions. And then, of course, another place is to go to the FinCEN website, where there are a large number of self-help materials, including the list of the exempt entities and including the details behind that. So, so I'm going to leave it there and stop talking. And so that way, maybe we can let Andy jump in, and then also see what types of questions we might be able to answer during the live time.
Yeah, I don't know that I have much to add other than, again, there are criminal penalties here. These potentially involve some of your entities that you have organized yourselves, as well as your portfolio companies if you're an investor. The general partners or whomever at your funds that serve on boards of directors may have to, have their personal information provided to FinCEN. One way around that is to get a FinCEN identifier if you're a general partner, which Elizabeth can help you with, or whoever. But this is a big deal. Go ahead.
Yeah,
Go ahead. I'm sorry.
Oh yeah, sure. On the identifier, let me just interrupt there. That is something to those we've already promised it. We're following through on getting them their identifiers. But I have found that having the service provider, at least the way we're doing it, is more cumbersome than having the person just directly do it. It can take them a very short time to go in with their own email address, because when they have not set up a portal just for identifiers. So you have to do a PayGov, set up a PayGov account, which is specific to one person. And so the PayGov account has to then be transferred back over to the client. And so that becomes cumbersome, that the person then has to schedule time with me so that we can have them click on the link from the US government and get it transferred over. So it can be, I think, less cumbersome for the person to obtain the identifier, because then they could do it anytime they want when they have 5 minutes to do it. And for those who need help, what we can do is I'm happy to schedule time, and, and then we would just walk through it together. But yeah, so sorry. So that's the one thing on the identifier. FinCEN has not made that user-friendly. For thirds, I should say, it has not made it user-friendly for using a third-party service provider. It is user-friendly for the individual directly doing it. On the reporting, that's where I think it is useful to use either myself or an outside service provider to make sure you're pulling together all of the information and submitting the report accurately.
I will just add that that there is, you may or may not have heard that the Corporate Transparency Act, which is the body of law, the statute that requires the beneficial ownership information filings, was the National Federation of Independent Business won a lower federal court ruling in a southern jurisdiction, and that has been appealed by the Department of the Treasury, Janet Yellen, et cetera. This court is viewed as, I'm not an attorney, however, this court is viewed as somewhat, certainly right of center. And, we are personally not hanging our hat on a successful appeal of this being declared unconstitutional. And I think one of the things that Elizabeth has made clear to me, and I don't recall if she mentioned it here, but waiting until close to the deadline on this at the end of this year is probably a mistake, because I think Elizabeth has some real concerns that their system is going to crash. Again, we're talking about 33 million entities that are going to have to file, and this is the first year. So anyway.
Yeah, and with the thing that concerns me is it's not just entering data on the company, as we discussed. It's potentially, with one company report, maybe you're uploading 10 passport images in addition to the data on the report, which could then be, multiple pages of data. So the data itself doesn't concern me as much as, that amount of uploads of the size of those files, and then everyone trying to access at the same time. So I'm very concerned, just having worked with other government portals for other legal areas. I'm just going to go through some of these questions. Here's a question for BOs who you need to disclose the tax ID. So for individuals, that is their social security number question. Yes, if, for example, if you are a small business owner and you have the option to get an EIN, which is a separate tax ID for the business, or you could just use your own social security number for your business. Well, if you are using your social security number, then yes, you are providing your social security number. And so, yeah, it goes back to my concerns for privacy and a honeypot of information. And let's see, here's another question. Please inform me if you have additional seminar with this topic. Thank you. So Andy this is the second time we've actually done the same presentation trying to capture the Moss Adams clients. I myself I provide training. I do presentations to my clients. And so I don't do it on a individual sign up. I do it for one company at a time across their departments on CTA and other types of compliance issues. So you can see that on my website. There are also, some different conferences that either online or in person that have been covering this. And then, of course, FinCEN itself has the materials. Okay, so working our way down. Are all VCs exempt? Smaller VCs may be exempt from RIA registration. Does that exemption nullify the FinCEN exemption? So what you would have to do is look at the specific details of the particular exemption you think is applicable to you and see if you qualify. In this training, I am not going to give any concrete answers as far as whether somebody is exempt or not. I'm happy to take anybody on as a client offline and work through whether you are exempt, but I'm not going to provide that legal advice.
Let me just jump in real quick and emphasize something that I think you said already, Elizabeth. The term beneficial ownership information, ownership. Unfortunately, ownership includes control. So if you are a board member, as a for instance, of a portfolio company, and you don't own directly or indirectly 25%, but let's say there are 3 board members and you're one of them, you have more than 25% control, so you're considered to be an owner, and therefore you would have the company upon which you're a board member would have to provide your information as part of its BOI filing. So it's not just ownership, it's control, management as well.
I may have misunderstood. Yeah, the good point, Andy. I may have misunderstood that particular question. So yes, if you qualify for, a investment advisor exemption because that's for your company. That is not when you choose to sit on a board of a company that must be reported. So if that's where you're going with the question, then the one thing doesn't exempt you. For example, if you're sitting on a board, the exemption goes to companies. Is this company a registered investment advisor? If it is, and it meets the requirements that are laid out for that exemption by FinCEN, then that company is not a reporting company. So the exemption.
Thank you. And I was just saying this in general. I was making a general comment because looking through the questions, and there seemed to be focus in the questions on the 25% ownership, but we also have to consider control. Right. I apologize. I've got to get on another thing. We're almost out of time.
Okay. Yep. Let's see. Tax exempt entity. It's based on U.S. law, and so a tax exempt entity under U.S. law, such as a 501c3, and the parameters for that, all the parameters for these exemptions can be found at FinCEN, and you can look at my blog posts, and then, we can go from there. And I don't mean, I see what you're saying, tax exempt. This is not tax exempt from a pass-through perspective. When we say tax exempt, we mean nonprofit. Okay, either the state, Elizabeth, can you please email this? Can you please email this list? Thanks. I will provide the list to Andy to send out. What if my company uses a common pair? Okay. Yeah, so this person's got it right. It's nonprofit. The nonprofit is what we're talking about when we say tax exempt as being one of the 23 exemptions. I'm just scanning through these quickly because we're out of time. everybody on the board. So even though Andy just, was trying to give a simple example of, the 4-member board, it's even if it's a larger board, they're looking for all the board members. So even if there's, 6 or 7 people on the board, all of those people are going to be beneficial owners. And so
thanks for clarifying.
Yeah, so that it is very expansive just looking at that question. A company owned by another company, you have to look up through the companies. And so if the Delaware company is owned 100% by the Cayman company, the Delaware company, you are looking at the executives, if any, the board, if any. Then you're going up to the Caymans if that's 100% owner, and you're saying at the Cayman level, are there executives? Is there a board? Are there owners of the Cayman company that are 25% or more? So we are looking through the companies, trying to find, are there individual human beings who ultimately have 25% or more ownership or 25% or more control? So I think we'll leave it at that. And I will get a printout of the questions and see if any of these are ones that I can just generally answer. And I will send to the Moss Adams team the list of exemptions. And then you'll be able to go from there. Thank you so much, everybody, for joining us today.
Thank you, Elizabeth. We didn't have time to answer your questions. We will do our best to follow up with you as soon as possible after the webcast. Here is a link to an online survey where you can provide feedback for today's presentation. Please take a moment to complete the survey as your feedback is very important to us. Thank you so much for joining. We hope you'll join us again next time.